Good evening, everyone. Once again, thank you, Sunil, for those wonderful words. Let me introduce Mihir Govilkar, today's speaker. He's an advocate by profession. In addition to his LLB, he holds an MBA from Johnson & Wales University, USA, and an MSc from MSc in France, MSc in Finance from EDEC Business School, France and Finance got mixed up. Mihir is a certified mediator and is also the founder of Mediation Initiative. He is currently a partner at Govilkar and Associates LLP, a full-service litigation firm based in Mumbai. He has written several articles on law and mediation and works towards creating awareness and promoting mediation as a dispute resolution method. He also conducts various webinars on mediation, and I got in touch with him while attending one of the webinars. Let's welcome Mihir. So I'll just give an introduction about the mediation. So I think there is a confusion about mediation and meditation. Mediation is not meditation. As I said, after our mediation, people go for meditation. It's a form of ADR, that's alternate dispute resolution. When there is a dispute between two parties in relation to family, commercial, or any sort of dispute, there is an impartial mediator who is being appointed, who will be discussing between the parties, and he'll try to sort out the dispute between the parties. So most of the mediation, after the mediation, the matters get settled. Instead of going to court and going for a long trial, etc., it really helps the parties. So many acts are being introduced. MSME, RERA, and various acts have been introduced wherein they stipulate that before you come to court, just go for mediation, and if it is not getting settled, you come before the court. So I am not taking too much of time in explaining about the mediation, but I would like to explain, especially the CAs over here, that there is a district Rotary Mediation Service Center which we have introduced, in which I am the registrar for the time being. And they are encouraging all the CAs and advocates from all the clubs to become a part of it. And this is purely for helping the Rotarians who is having dispute in their professional or personal life, family matters, or whatever. And so we are encouraging all the CAs, and Sunil, you can also put up an application there and become a part of it. Somebody will be coming here and then explaining in detail about the district Rotary mediation program. And I'm not taking much time. Mihir, over to you. Thank you very much.
So I acquired some qualifications as I was growing up. If you ask me the story of how I acquired these qualifications, it's not really very interesting. But it was definitely challenging. And it does help me in my current profession now, having been in different domains and industries. I became a certified mediator in the year 2021. Before I became certified, I was applying similar principles of mediation in my job while attending to different clients. I did not know I was mediating at that time. When I became certified, when I underwent the training, I understood what needs to be done better, what needs to be done differently. I got certified by two institutes. One is through Indian Institute of Corporate Affairs, which comes under the Ministry of Corporate Affairs. And the second is an institute called ADR ODR International, based in London. And through that, I got registered through the Civil Mediation Council UK. And it's also a Singapore Institute of Mediation certified program. And just as a hobby, I collect fountain pens and would like to start collecting watches. All right. Now coming to mediation, as Deepa said, it's an alternative dispute resolution mechanism. And I know I have about 30 minutes, but still I would like to keep this as interactive as possible. And I hope we can make this more conversational than just me speaking. So if I could get an idea from some of you, what do you understand by the terminology ADR, which stands for alternate dispute resolution? Anybody? Yes. Exactly. There is no other simpler answer. Instead of going to the court, you adopt an alternate means. Now, does anybody know what are the alternate means? No. So let's come to mediation later on. But this term ADR. So the gentleman over there said that it is out of court. Instead of going to court, you adopt an alternate method. So does anybody know what these alternate methods are? Has anybody heard about them? Exactly. Yes, exactly. So arbitration is one of them. And what has happened is over the years, because of the way it was promoted internationally and in India, arbitration is considered to be the only alternate dispute resolution mechanism. But that is not true. In and around the 1970s, mostly in the USA, mediation started gaining popularity. Then it spread to more Anglo-Saxon countries, then in Europe. And it might interest you to know that one of our oldest laws, is the Industrial Disputes Act of 1947. Mediation has been incorporated in that as well. But unfortunately, in practice, as we see, there are lots of comments about how our laws are outdated, they're archaic. That's not really true. Most of our laws are beautifully enacted. It is the application and the practice which proves to be challenging. So the provisions are there, but the application, like I said, is the challenging. So now, what is mediation? Mediation is an ADR mechanism. In mediation, there is a mediator who is a neutral third party. Now, what that person does, he does not pass any order. He does not give a judgment. There are no rules of evidence involved in a mediation. If anybody is familiar with court procedures, you know that evidence is one of the biggest challenges that you can face in a suit. So, like I said, it does not involve any evidence. There are no petitions. You don't have to file anything. Then your question might be, then why should I go for mediation? What happens in a mediation? Let me clarify at the very start that it's not a magic wand. Not everything can be settled through mediation. But whenever any question pops into your head, can I settle this dispute through mediation? I would like to ask yourself a counter question. Is there anything stopping me from settling this through mediation? So that's the counter question I would like to start. I'd like everybody to start asking. I've been a lawyer for about 6 years. My father has been a lawyer for 47 years. And I have seen how much time and money and effort and energy is spent in the courts. I have seen what the pendency in the courts can do to people. It's not easy. It's very difficult. It's very stressful. I earn my bread and butter through litigation, but I still believe that litigation should not be the first dispute resolution mechanism that you should adopt. Yes, sir.
Does it apply only to civil matters or including criminal?
In criminal matters also it can apply. There is a concept called as compoundable offenses. Under the Indian Penal Code, there are offenses called as compoundable and non-compoundable. What compoundable means is these offenses, can be, the parties can reach a compromise. So in criminal matters also this is possible. So, like I said, although I am primarily a litigation lawyer, I still believe that mediation should be your first choice. And why do I say that? Now, if let's say, God forbid, you have a dispute of some kind, you will approach some lawyer, and that lawyer will advise you, okay, you do this, you go to the court, you file this, you do that, and do this. No lawyer, except for people like me, will advise you to go for mediation. Thank you, sir. There are a few reasons for that. First of all, mediation has not really been practiced well in India. Because of that, there is hardly any awareness about mediation. And thirdly, because of this lack of awareness, the notions about mediation in people's minds are completely different and most of the time wrong. A mediator is not simply a person who just sits there and says, okay, aapko kya chahiye, aapko kya chahiye, acha, do you agree? No, theek hai, chalo, nahi hota. Nahi, that's not it. Unfortunately, we don't have a time to discuss the entire step-by-step process and all the techniques and the stages that a mediator goes through. But there are several stages. In our training, we learn primarily how to ask questions. It might seem to be a very straightforward, simple skill, but no, it's a very difficult skill to ask the right questions. Because what may be troubling you may not be easily recognizable to you yourself. There is a very famous case in Brazil about a huge conglomerate where the owner was in dispute with some other company and they wanted to demerge. And after a lot of probing, the sticky points were the non-compete and the intellectual property. After a lot of probing, because they were stuck on the valuations, I want this much, I want that, I want this, I want to do that. And after a lot of probing, the mediator finally got to the root of the person's interests. And he said, at this age, he was well above 70 and a multi-billionaire. At this age, I want freedom. And then they structured the deal around that, and he was happy. He was even happy to make a lot of compromises because he got the freedom that he wanted. So a mediator will also try to unearth your positions versus your interests. Now, for that businessman, his interest was having freedom to do what he wanted, but he had stuck to his position of, okay, I want this much money, I want ownership of this and that. But when the discussion started going on about freedom, that's when the issue started unraveling and it was resolved. So a mediator will try to understand your interests, your positions. We also call it expanding the pie. In mediation, it has been the experience that when two entities are doing business with each other, or it might be a dispute between families, or between a cooperative society housing managing committee and a member, or between two members, it has happened that the end resolution of the dispute goes beyond the initial complaint. Because let's say if it's a business entity, two business entities, and they have a long-standing relationship. Now, while discussing one dispute, they start talking about other things, and they come to a resolution on things that were not even a part of that original dispute. So this is called expanding the pie. So this also happens in mediation. So the role of a mediator, to put it very simply, is to, yes, to bring the parties to an agreement. Now, that is the skill, that is the training, that is the experience. So if tomorrow you say that, yes, I have been able to resolve differences between my friends, my families, wonderful. You might actually have that innate ability, that innate sense of understanding how to resolve disputes. Great. So you can be an effective mediator. But I have spoken to other lawyers who say that I simply cannot be a mediator because I do not have that patience. I do not have that mindset. I can be an effective arbitrator. I can be a judge. I can be a good litigator, but no, I cannot be a mediator. So you need to also have that mindset. You need to have that patience. You need to have that ability to ask the right questions, to delve deep into somebody's emotions, their stories, to understand why they are doing something. If you think of any family dispute that may have happened in your family or in your network, if you start thinking about it a little bit, you might realize that the issue that the people are fighting about at that moment is not really something that should be fought about at all. The true reasons, the root of the problem is something completely else. So the mediator will try to ensure. Oh, it's still this line. Oh, it's on this. Okay, I'm sorry, the slides are not moving. So the mediator will take you through this entire process and hope to bring you to an agreement, to a mutually acceptable agreement. Now, what are the features of mediation? It is confidential. By agreement, it is confidential. And in December of 2021, a mediation bill was introduced in the Rajya Sabha. The scrutiny committee came out with its comments on the bill, I think about 2 months ago. And the law minister, if you read the news reports, he has been heard to say that the mediation law will come in very soon. So with that, what will happen is that before you go to the courts, pre-litigation mediation will become, at least that's the provision, will become mandatory. I hope they don't remove that. Because before going to courts, if you go for mediation, it has been the experience in many countries. In fact, Italy was the first country in the world to introduce pre-litigation mediation. Their pendency has reduced tremendously. There was a lot of objection from the lawyers initially, but then now what has happened is some lawyers have completely shifted their practice from being litigators to mediators. And they're doing wonderfully well. Greece has mandatory pre-litigation mediation. Even in India, we have pre-litigation mediation mandatory under the Commercial Courts Act. But there is a loophole. And the lawyers will always find that loophole. They will say that because there is some urgency, you don't need to go for mediation. You can directly approach the court. Yes, sir.
This is similar to what happened in the family.
Yes, the counseling happens there. Unfortunately, I think it all comes back to the huge pendency of cases. A counselor simply, I mean, it's practically impossible to, I mean, one mediation session should, I mean, usually lasts about 2 to 3 hours for one case. It's practically impossible for the counselor at the family court to spend 2 to 3 hours.
The law comes that for mediation. There is a lot of pending cases for
Yes, and that is definitely a challenge. That is definitely a challenge. That is definitely a challenge.
I think mediation is possible. Parties agree to that.
That is why the mandatory provision.
I think learn from what you have said is you are not giving any verdict or anything like that.
No.
So it is a win-win situation for both the parties.
Exactly.
So what question? Suppose mediation party has agreed. Will it prevent the person to vote again?
I'll come to that. I'll come to that.
Yeah, yeah. I think.
If that can be shown.
No, I think it is hard.
Go ahead. Go break your.
Yeah. So it is confidential by agreement and also by law. So if your concern is that if I go to mediation, everything will get disclosed to the public, no, that is completely not true. It is completely confidential because you enter into an agreement to mediate. Confidentiality is built into that. And there are several judgments of the courts where they say that mediation, anything happens in a mediation is confidential. So if you disclose anything, if you make any offers later on, if somebody wants to challenge that in the court and say, oh, he made this offer to me, he is ready to do that, or he accepted this. No, you can't use that. No. Under Indian law, if you look at the Registration Act, Section 17, all the compulsorily registrable documents are mentioned in Section 17 of the Registration Act. And mostly those relate to immovable properties. Every other agreement, every other document, you can register it, but it's not mandatorily registered. Then mediation saves a lot of time. There are no court procedures involved. No adjournment. Well, adjournments is fine. It's up to you. Sir, you are in control of the mediation process. No, court is fine. But if you go in mediation, sir, you are in control. Nobody else can choose that. If you say that, okay, I want to have the mediation on Zoom, yes, you can do that. If you say, I want to have it at 10 o'clock tonight, if both the parties agree, if the mediator agrees, why not? You can have it in a restaurant. Preferably not, because it would it should ideally be in a quiet setting. But if you own the restaurant, then why not? Then it saves money, obviously. It preserves relationships. Because the acrimony in the courts is terrible. I have a family case going on right now, divorce case. I urge them, I implore them to try and settle. They were not ready. And then I told them that if you do not settle right now, there will be lots of allegations made against you, your entire family in the court. And then at that time, you will have to deal with that. And then their counter question was, how can they do that? That is not true. Well, then they will have to prove it. But they can still put it on paper. Can you stop them? No, you can't stop them to put it on paper. They will put it on paper, and then you'll have to face that in open court. If you talk about confidentiality in the court, that's not at all possible, unless it's an in-camera case ordered by the judge. In-camera means in the chambers without anybody else. No, not at all. Confidentiality. You cannot, if the parties choose, see, the crux of the matter is if the parties choose to be malicious. If somebody wants to be malicious, if somebody wants to defraud you, if that is their intent, you cannot stop them. You can take your precautions, but if somebody wants to loot you, you can try your best defenses, but you cannot change their intent. Even in courts, we have clients who tell us that, okay, adjournment mang lete, let's delay this. That is always there. Yes, the dishonest party will always try to do that. And that's why I said it. They will not. But that's why I prefaced my talk by saying that it's not a magic wand. You can have minutes, you may choose not to have minutes, but at the end of the mediation, everything has to be destroyed. Destroyed. No, not necessarily, but you need to know the law. If at the end of the mediation, you reach a mediated settlement agreement, if in that agreement, the parties say, okay, I'll smuggle 10 kgs of gold for you, you pay me this much. That is against the law, so that agreement is not legally valid. So you need to know that. Yes. Common sense, logic, application of the law. Now, I'll give a small example or something for everybody to think about. If you are in business, if you have a business with somebody for a long time, you have good relations, but somehow, unfortunately, there is a dispute about something. Maybe about the quality of something that was delivered to you, whether it was product or services. And negotiations between the senior members have failed. But you know the importance and the value of that relationship. What remains with you? Go to the court or arbitration. But then you are in a win-lose situation. You are in an adversarial situation. Why not try mediation? There is nothing, you don't lose any rights. It is completely voluntary. It is confidential. It saves you time, money. The process is in your control. The mediator is trained, is experienced to guide that conversation.
How is it different from arbitration?
Arbitration, so think of arbitration as court procedure out of the court. So the arbitrator can be a lawyer, cannot be a lawyer, can be a retired judge, it can be an engineer, it can be a doctor, it can be anybody. There is no requirement for an arbitrator. There are certain restrictions on who can be an arbitrator, in the sense it cannot be an interested party. That cannot be an arbitrator. The arbitrator passes a final order, which is called an award. So there is judgment, there is adjudication in arbitration, there is adjudication in litigation. In mediation, there is no adjudication. The power and the control is with you, the party, about how the dispute ends up. And it has shown tremendous success all over the world. But if your only concern is what if the party doesn't show up, well, the mediation has already failed, hasn't it? But you have tried your best to resolve the dispute. Right? I'll just move on quickly. So the types of dispute that can be gone into is all kinds of civil, commercial disputes, family disputes, vendor disputes, even workplace disputes, ego clashes, territorial jurisdiction, that's a legal word, but let's say a sales area assigned to the sales team. There is a classic battle always between the logistics team and the sales team, HR and everybody else, the legal team with the entire company, even with the CEO, because the legal team will always tell them what is legal and what is not, and it many times does not help them with their business decisions. So it need not be an outside mediator. You can have somebody trained in your company as a mediator, or you feel that somebody from outside should come in, a neutral person, then that can happen. But you need somebody to resolve your disputes. And managers, unfortunately, and higher up, especially the C-suite, because they have reached that position, they feel that they are problem solvers. They can resolve any disputes. Some people are definitely extremely capable. But I'm sure in your vast experience, you'll realize that not all of them are capable of resolving disputes. That requires a different skill set. A CFO may not be able to do that. Right? Just as an example, some CFO might be. But you as the head of, or if you are in charge of the decision-making process, you need to evaluate and put your ego aside. Who is the best person to resolve this dispute? Then we already actually talked about arbitration versus mediation, and now we come to the legal sanctity. At the end of the mediation process, people will enter into something called as a mediated settlement agreement. That agreement is like any other agreement. You can choose to enter any details, any information that you want to. That agreement remains between the disputing parties. So unless you choose to expose the confidentiality and breach that, it doesn't have a template. I'm sorry? Stamp duty should be payable. I know what I'm saying. Stamp duty can be paid by 3 ways. On a stamp paper using adhesive stamps, or by franking, or now online also through e-challan. So your lawyer should be advising you what is the stamp duty applicable on any agreement. It's a table that tells you what is the calculation for any agreement. What is the stamp duty value? I have come across several companies, innumerable companies, who simply do not pay the stamp duty on any agreement. And do you know what happens when that agreement goes to the court? It is not invalid, but it is inadmissible in evidence. You cannot use that as evidence if stamp duty is not paid. Then the court will impound it and then send it for adjudication. Or before filing the suit, you know that you have not paid the stamp duty. So you yourself send it for adjudication, you pay the stamp duty and penalty, and then place it before the court for evidence. No, unless it's a compulsorily registrable document, it need not be registered. But stamp duty is payable on documents. There is a whole table in the Maharashtra Stamp Act, Schedule 1. It gives you everything. There are, in some cases, there are fixed court fees. There are, in some cases, we call them ad valorem court fees. Yes, stamp duty is payable. No, you don't pay that. Because, see, if you go for a mediation for a divorce case, before they go to the court, what happens is, if they agree on something, then they file a petition for divorce by mutual consent under Section 13B of the Hindu Marriage Act. If they are Hindus, if they are of a different religion, then different laws will apply. If they have already filed a divorce petition and then during the process they realize, no, we want to settle, then that petition can be converted to a petition for divorce by mutual consent, and a consent decree will be passed. Now, the objective in all this is to help people come to a resolution of the dispute. And I actually love this here. So if we look at this, the four-way test of the things we think, say, or do, the mediator will think about these. I'll come to the first one a bit later, but the second, is it fair to all concerned? Who decides that? You yourself with the other party. You will enter negotiations, the mediator will guide you, will help you. The mediator will make you think. Now, for example, if you know, as a mediator, if you're a lawyer, let's say, for example, and you know that if this goes to court, this person will certainly lose. So there are different styles of mediation, facilitative, evaluative. In facilitative, you don't give suggestions, you don't give your opinion. So then you can ask them, okay, have you checked the law on this? Why don't you check this judgment? So then the party will realize himself or herself that, okay, yeah, this goes against me. I should not go to court. Let's try to settle here. If you adopt evaluative mediation, then yes, mediators can go. But then the general idea of mediation is that it is party-centric and not mediator-centric. We want parties to have the power and control over what the outcome is. If the mediator starts giving his or her own opinions, ultimately it could be said that nahi, mediator ne bola, humne kar diya. And then it again goes to litigation. Kya fayda fir mediation? The mediator is supposed to guide. He is supposed to give information. He is supposed to ask the relevant questions. He is supposed to make the parties think. Of course, we cannot go into the extremes of what if it's a person of unsound mind, then he can't be a part of mediation anymore. If it's a malicious person, if he has malafide intentions, then no, again, mediation will fail. If a person, and again, in an extreme case, lacks the basic common sense, again, you can't help that situation. But we are not talking about extremes. We are trying to look at the mass population where people want to resolve the disputes. They want to maintain and preserve their relationships, build on that, go on ahead with their lives. So that is what it is. And there are a couple of other ways you can finalize the agreement. It could be a mediated settlement agreement. You could, it's a bit technical, but you could kind of convert that mediation proceeding into conciliation proceedings under the Arbitration and Conciliation Act of 1996. And then have that agreement deemed to be an award. You can file a suit in the relevant court, and everybody agrees that this will be the outcome and get a consent decree. Yes, so just give me a minute. So this kind of is a gist of what mediation is. I take every opportunity possible to make as many people aware about what mediation is and how it can help them. I hope this gives you some information, some idea, hopefully, that if next time you're confronted with some dispute, you'll at least think about it. So I end here, and if there are any questions.
There's a case there between a builder and a buyer. The first case, hearing itself, they say they go for consultation.
Yes.
In that time, the consultation time can be mediator pay over there.
The consent. Okay, so there is a confusion about these two terms, conciliation and mediation, but for all practical purposes, they are the same. The conciliation proceedings are a part of the act. So whatever settlement you arrive at, the RERA will have to look into that and pass an order accordingly. Yes, sir.
Once the agreement is, you consulted and the mediator has come, and you have signed the agreement, both the parties have agreed, they signed the agreement. After 1 year or so, one of the parties, they decide, "Arey, हमको उल्लू बनाया, very good."
उल्लू कैसे बनाया?
You कैसे बनाया? Please, see, I agree, maybe due to some, that environment, that condition, I agreed and all. After 6 months, I'm just asking, I don't believe. What's your agreement in the mediation process? Will it prevent you?
I'll tell you, sir, what happens is when in law, especially, what happens is when we talk about hypothetical situations, the answer always depends on several other facts. Were you aware of it? Were you given the chance to look into all the details? Or is it just buyer's remorse or seller's remorse, whichever side you're on? यार ये कम में बेचा, that is seller's remorse. Buyer's remorse is ज्यादा में खरीद लिया मैंने. Which side are you on?
No, I think, so in case of breach of any of the terms and conditions of the
Yes, so breach of contract. No, he's saying that if he feels that he is defrauded.
Yeah, that's one, either way, can one of the parties go to court and represent what it does?
Yes, so are you talking about fraud or are you talking about breach of contract?
After the agreement, mutual agreement,
Mutual agreement, I agree.
हाँ.
Very hard. Okay, हमको 50% देना, तुम 50% दे, आप कितना दो?
it changes the price.
नहीं.
80% on that.
No, you agreed.
That's what it's binding. That agreement is it, when you sign the agreement, I'll take.
You are bound by it, and so is the other party. But if you're alleging fraud, then we'll have to establish what is the fraud.
So you will say whatever mediation process which has taken place all over the world till date has never gone to the court.
No, I'm not saying that. No, but what is the basis for going to court? Is it fraud, breach of contract?
He realizes that at that particular time, I was convinced that
What he says is okay.
the situation
Right.
was that
No,
I
so
did.
then you can't.
Now I feel that it was not correct.
Okay, I'll give you a simple example. When you purchase a flat, you enter into an agreement. Are you not bound to pay for it? That price. It's an agreement. If it's a legally binding agreement, if you are of sound mind, if you are an adult, if the object of the contract is legal, if the consideration, which is a legal term, if whatever is exchanged is legal, then the contract is enforceable.
Here also nobody forced you to take that. You mutually agreed.
Sign the agreement.
Yes. Yes, sir.
So coming back to the translation, like in case of we are asked to do so how many such conversations
It's very simple. It's very simple. It's very simple, sir. No, so it's very simple, sir. It depends, first of all, on the nature of the dispute. If it's complicated, let's say it's a big company and the directors are fighting over making separate entities out of it. And it's a question of calculating the percentage and who will get which market and all those things. And if the discussions are progressing smoothly in the mediation, and if you're reaching certain milestones, then nobody really cares about the number of sessions. But even if it's the simplest case, and like this gentleman here was saying, कि सामने वाला party आने को ही मना कर दी, mediation fails right there. Lekin, let's say the mediation happens for one session. They think that, okay, there is some progress. They come for a second session. They feel that there is some more progress. And then there is a third session where they feel that, okay, this can go nowhere. We don't want to come. Mediation fails right there. What you need to remember, sir, is that the control lies within you, with the parties. Nobody else can force you. It is completely voluntary. But it has been empirically observed that mediation succeeds.
I'm asking the already. What has to give us a chance for we can say no more time.
No, not necessary. But then, sir, you can decide to end it.
What do we say? Like,
Yeah, I don't want to come. And there is no and sir, there is no there is no mediating authority. If, for example, two people have a dispute and they come to me and say, Mihir, you please mediate the dispute between us. No court is required for this. Those parties appoint me as their mediator. Like we say, Mia Bibi Razi to kya karega Qazi? If the two parties agree that this person should be the mediator, nobody needs to appoint anyone. Having said that, in lots of disputes, the court also says that, okay, we think, or I think that this is a fit case to go for mediation. They have certain people on the panel, or they feel that, okay, this lawyer I know, I've seen him appear before me, I now know how he is or she is. I'll appoint this person as a mediator to mediate the dispute. Then that person mediates. If it succeeds, it sends a report with the settlement terms, that mediator. If the mediation fails, the mediator sends a failure report. It can be multiple also.
But you don't require anybody to support.
No, it is advisable. If there are questions of law also involved, then it is advisable. Yes. Because ultimately, when you're drafting the mediate settlement agreement, it is advisable to know what the terms are. Exactly. So when you're drafting the agreement, it is advisable to have a lawyer present there or later on and tell him, these are the terms that we have agreed upon. We want to draw up an agreement based on these terms. Please advise me. Like I said, it is advisable, not required. For example, I believe you're a CA. So if it's an accounting matter, dissolution of a partnership, would you not like to have, or would you not advise your client to have you present there when they are talking about the percentages and how it should be dissolved? Maybe a lawyer should also be involved, because if they're talking about the dissolution of partnership, whether the firm itself is being dissolved, or it's just the dissolution or the retirement of one partner from the firm, that also needs to be looked at. The terms of retirement in the partnership deed will need to be looked at by the lawyer. Yes.
Most of the mediators are lawyers at the parties, so they are not independent.
No, so the thing is that if you want to get empaneled as a mediator with the Bombay High Court Mediation Center, you need to at least have 15 years of experience as a lawyer or 15 years of expertise in any field. You need to establish that you have that expertise. Now, Mr. Bhatt said he has been a marine engineer. So if there is a dispute regarding his field, and if he is able to establish that he has at least 15 years of experience in that field, and he wants to be a mediator for such kind of disputes, then yes, obviously. And sorry, I just wanted to come to this. Is it the truth? Does it really matter in mediation? Exactly. So if you hold on to, nay, this is what I was supposed to get, I should get this, I had bought this, or this was given to me. If you're stuck on your position, Unless the other side agrees, it won't happen. Because you're not going there for adjudication, you're going there for resolution of your dispute. Unfortunately for you, you are in a dispute. There will have to be some give and take. If there had been no dispute, obviously everybody is happy. But that is the truth and fact of life, that if you're in a dispute, there will have to be some give and take. If you go to court, it will be time, money, effort. Arbitration, the same thing. Mediation also, yes, but a little bit less, quite less actually. According to statistics in India, to recover money, you have to spend about 31%. I'm sorry, I've taken up more than I was allotted. No, so this is applicable, yes, of course. But then I said I'll go through this and then come to this, because in mediation, your agreement and your satisfaction matters. If you come to a realization that I know that this is not the truth, these are not the facts, but I want to settle this, I want to maintain this relationship, I'm accepting, I'm taking a back step. All right. Thank you so much.